take position as there's a massive, like petitions for the governor to veto it. So anybody that wants the changes that are in there, you have to kind of understand them, because if you want to change,
Carol, you're fading in and out really
the
badly
governor
again.
sign it.
Carol, we're missing about half of what you're saying because your connection is not stable.
Governor has to sign.
No,
We can't hear you. I have a
Zoom
question. Is it an all or none bill?
Oh my God.
Is it what?
Is it all everything, or are can they take things out?
I'm talking to myself.
Yeah, they took some things out as in order to get it passed. Not significant parts of it, I don't think. But the extreme changes.
I mean, I don't think anybody saw this coming up, did they?
No. If you look at the act and you find poor Katie Stewart's act in there,
oh,
it's just a little drop in the bucket.
she got hijacked.
She got run over by a Mack truck, because it's not even at the beginning. It's like about, I don't know, how many pages? 50 pages in. It's about 10 pages, and the whole bill is
600 pages.
Yeah, 560. And yeah, it totally changed everything, and they had only so many hours to review it. Fortunately, like the pretrial release thing, fortunately, that had already been reviewed, I think, by a lot of people. So they were familiar with that. But I think a lot of the stuff just really was thrown on them. And I think the more excessive change, well, that's my terminology. The more extreme changes, different changes, did not go through.
Oh, okay.
But there are a whole lot of changes that are in there. It's going to be a nightmare for.
I think a lot of that had been, I think a lot of it had been discussed, and the police were upset because they said they didn't have any input into that. But I think they have been meeting that. That bill that presidential thing, that what, even the name of it, whatever it is that we've been referencing, that was the task force under Obama, has a lot of these things in it, and it was approved by Maine police.
The things that were not included, Carol, I don't want to hear. I'm sorry. I want to hear what was taken out, and I want to hear that was in the Obama thing that we talked about.
Okay.
So far, nobody's been able to tell me what was left out.
All right. I can't lose my Zoom here if I go and look for that. I'll look for it while you're talking, but
no, I'm not going to be talking because you've totally changed what I was going to do.
Well, maybe you can tell us what you know about it, because we don't know anything. And one question I have is, can the governor veto parts of it, or is it all or nothing?
Yeah, that's my question also.
Well, does the governor,
I don't know if he has line item veto. I don't.
Well, I'm going to Google it right now. As the kids say, Google it, Mom.
Okay. One of the things that has come up out of all this mess, besides I think it wouldn't be too bad in the near future or sometime down the road to have a meeting on how bills are passed and what can be done and the time limit and all this time. Because this just came out of nowhere, as far as I know.
Yeah.
Well, the reason they did it, right, I don't know exactly, but Katie's bill had already been introduced, and so it was in the process. And so then when they added the amendment, if they would not have been able to get a reform bill introduced during that veto session. But because they added it to a bill that was already introduced, then they got it in.
Then Carol, they could wait until today, which is the new session, and introduce their bill. Why do they have to jam it into a short session?
I don't know, was there a big, what the change, is there a big change in the people that are in this one from the last time? Do we have new people coming in, or I don't know.
Or what?
Now the new people are already in.
They're already in. I don't know
And wasn't
why.
this at least like 4
That's
bills
their
that got
problem.
put together? This is like 4 different bills that got put together and crammed onto this one.
Here we go.
Right.
Line item veto. In total veto, the governor vetoes the entire bill. A mandatory veto. In an amendatory veto, the governor makes specific recommendations for changes to the bill. Included with an amendatory veto is a quote veto message, end quote, indicating that the governor would sign the bill if the recommended changes were made. And then it says what the options are. And then item veto, applicable to appropriation bills only. The governor may veto any item of an appropriations bill. An item veto allows the governor to change a bill if the governor basically approves of it, but finds some parts of the legislation unacceptable. The portions of the bill that are not vetoed become law. So that's only, oh, there's a reduction veto. Oh, that's applicable only to appropriation bills too.
What is a,
So basically he's got that amendatory veto thing. But the
Has there
governor,
been any talk from Pritzker's office if he's going to approve it?
I
If
think
he's
he
going to
will.
be,
I think he'll approve it.
He put out a positive
he'll
piece
be-
on it, a little PR release saying he thought everything in it was very good.
Yeah.
what? There was a I read an article, so where was that? Champaign police officer? I read some different articles. I'm trying to find what they changed because they took out a bunch of stuff that was controversial. And because it's, what I had read before said there were 3 senators that were holding it up. And one of them voted, Crow and somebody, oh, Menard voted for it. Crow and someone else still were Democrats that voted against it.
No, they did not.
Crow
No, they
voted
did
against it.
No,
Yeah,
she did
Crow
not.
voted against it.
Yes, she did. She voted not to accept it.
It said that the only people who voted against the amended act were the Republicans, all the Republicans.
There were
Or maybe
2
because
Democrats.
it was amended, because she had said up front she was against it
Yes,
before all
in
those
the
changes
beginning.
happened.
Before the changes, then all the Democrats voted for it. What the articles that I read, let me see if they've got it in here again. I read a bunch and then I took the one that gave me the most information in the shortest period of time.
Well, I know all the police departments are against it.
That was before the amendments. That was before the amendment. I'm not sure about afterward, but they've got to be, because
The Champaign one, whoever I read said that it had good stuff. He would work with the government on it. Of course, he's a Democrat.
Oh, I read somewhere today that the State Association of Police Chiefs were for it.
Really?
Yeah, it was the police chiefs. I don't know whether there are more than one organization of police chiefs or not.
no, there's only one. I'm Googling this Rochelle Crow thing too.
Oh, my internet.
Let's see if I can spell right.
So it was called House. It became House Bill 3653.
Yes, because it originally was 163. That was the original bill, and it just had to do with tracking opioids prescriptions, right?
It was 163, right?
Yes.
Yeah.
And then they attacked this on the, and somehow it got
Right.
renumbered. I don't understand that process.
When the severe opposition was expressed regarding this dangerous bill, which was the first however many pages of the amendment was to the bill, legislators moved the wording into House Bill 3653. And then, oh, well,
Yep,
this
you are
talks,
correct. Rochelle Crowe did vote against it.
there were two people that did, and Andy Menard voted for it,
Yes.
and
And
he might
Jason
have been,
Plummer voted against it.
well,
Shut,
okay, so we're recording this too.
don't care.
I know, but I'm just reminding people this is recorded.
I'm not
Crowe?
happy with the number of people who are here.
Yeah, our local people, Rachel, right, Rochelle, no, I know, but it's gonna be on our site for people to see.
But weren't you supposed to have someone presenting something?
Yes,
And she's not here.
Jane is here, yes,
Is she? Why
yes,
don't I
right there.
have everybody?
She's here
How do
right
I-
now.
Jane, you're muted.
How do I do that, Becky? Get everybody.
Up in the,
Probably have to scroll left to right because it's only however many show up on your screen. And you have to remember to go up and do grid view. So you can see more than just the
Gallery
person speaking.
Gallery view, maybe?
Grid view.
There we go. There's a people. There's Jane. I stopped it at Sylvia. Okay. Sorry. Yay. It's been a long day reading fine print.
Has anybody contacted the chair of this committee at the state level to see what they're saying?
Are you kidding me? Sorry.
I thought maybe Carol June did.
No, it sounds like a very smart thing to do.
they're a day late and $1 short on this study because this is,
Well, I think everybody was shocked by this, not just we.
well, you'd be shocked in a way, but I wasn't shocked. I mean, I knew something was
You
gonna
knew
come.
this bill was gonna come up?
I knew they were
in a
gonna,
lame duck session?
I knew they were gonna try to push something through on the Pre-Trial Fairness Act because I was
Right.
getting call from everybody.
And that's
that's part of it.
300 pages long. You
I
know,
know, but it's
and
part of
one issue.
it. And so,
And one issue. I can handle that. This thing covers,
And the other thing, I know there was a big push about the no money bail. There
right.
was a group for that only.
that's,
Talking about all this other stuff.
that's the Pre-Trial Fairness Act, right? Well,
And the police were all the agencies were on okay with. It's all the other stuff that they push through
That's
that
right.
is a problem.
the police agencies, but I've seen people and in articles where there's, and maybe some police are saying that not everybody, that they were not in support of all that cash bond being taken away because I think they were, I don't know if they understood that. I don't think that works for, well, I guess it does say, I guess people, they'll do a risk assessment. So if it's a violent offense, they could be held in without, they're still not going to do bail then, or they just can't get out. I don't know.
Well, it's all there in the Carol. I could tell you all about it, but
All right, you can tell us when just, Jane's going to do her part first and then,
you're going to need a month of Sundays to get through that act. But go
well, we're
ahead.
not going to go through the whole act. We're going to go, you can talk about the things in the act maybe, or else we need to look at the questions and then reference the act, since you know what, you can reference and say, this is what they said about it.
Okay, you'll have to give
Well,
me to find it.
you know what? Joanne and Carol, some of you know more about this than I, but when the league is stating a position like this, it doesn't necessarily mean that it isn't in existence in the state in law. I don't think passing this law changes what the league position, does it? This is just the league's position, and some of the things may already be enacted in places and some not. It's just stating their position on them. Is that right?
Yeah,
I'm assuming so, yes.
It
Yeah.
will
So
stay,
the-
right.
But some of the things we talked about last time, like a recommendation that we could make about, Carol, about an independent prosecutor looking at it, well, that's in this new act. So you don't have to, we don't have to recommend that as part of our,
Well, but this is what I'm thinking is, what we're doing isn't a recommendation as much as it is a position on things.
yeah, it's a league
well,
position.
isn't that our position, that there should be an independent? I mean, I don't understand the difference. It's a wording.
It is, but so in our consensus questions, we will say, yes, you know, we're going to retain that position, that yes, we support that.
Mhm. In case sometimes somebody tries to change the law, we can speak up and say, no, we're in favor of that. I don't know, I may be wrong, but that was my
No, that's
thought
fine.
of
We'll
what the
go through
league
the
position
question.
was.
Okay, but are you going to have Jane present? And if so, Jane, you're muted.
Yeah.
There
Let's,
Where'd she go?
Are you ready?
There she is.
okay. James
I was
is
just-
gonna,
She's right there.
I'm gonna try to share.
Okay.
Can't hear you, Carol.
Again, Carol.
Carol June, you're a mess. Your computer's a mess. I'm sorry.
Okay, but Jane is ready, so why don't we move on?
I know, and the
Okay. Are you ready for me?
Go.
Yes.
he
Yes.
does, since my battery doesn't work on my. Let Jane, go ahead and do hers. I'm gonna try to pull this up and share the screen with what she's saying. Go ahead, Jane.
Okay. So this is a topic that was actually not in the materials that we got from the league. I got interested in this topic when I was reading a book from a different group. And so I was surprised that it would not be something the league would take a position on, because it has to do criminal justice and young people getting involved with the criminal justice system in large numbers. So I talked to Carol about it, and she said, go ahead and do it. So the question I came up with is, should Illinois school districts pursue ways to reduce the involvement of police officers in schools and reinvest the money in more school counselors, psychologists, social workers, mental health, and other programming for students? So the situation is that there has been a huge increase in the number of school resource officers. It ballooned in the 1990s, and today, I think in 2013 and 14, there were more than 43,000 police officers in US schools, and I'm sure it's more than that today. And along with that have come huge increases in the number of children arrested. According to the Department of Education, 92,000 arrests were made in the 2011 and 2012 school year. One study shows that schools with resource officers had nearly 5 times the arrest rate of non-SRO schools, even after controlling for demographics like race and income. And the great majority of law enforcement referrals are for misdemeanors and trivial infractions of school rules. So this increased criminalization of young people is referred to as the school to prison pipeline. And this is a quote, it is important to recognize that the increased rates of arrest are not the result of students behaving more badly. Instead, they appear to be a direct result of placing police in the schools. A 3-year study of schools in the same district with differing police presence found that the schools with police had nearly 5 times the number of arrests for disorderly conduct as schools without a police presence. The next point is that students of color, students with disabilities, and LGBTQ students are most affected. And so there, I don't know that you want me to read this entire thing. Carol has the document and can send it out to everybody if you want to read it. But basically, they've got numbers here showing that Black, Latino, and special needs students were disproportionately subjected to criminal justice actions. And it says it is not uncommon for the same behavior that triggers little to no response in many predominantly white communities to result in severe consequences in communities of color. Stories from the ground indicate that the same disparities exist in arrest rates and interactions with law enforcement for students with disabilities and LGBTQ and gender nonconforming students. Then this can be very serious for children over the long haul. It says research shows that a first-time arrest doubles the odds that a student will drop out of high school, and a first-time court appearance quadruples the odds. The American Psychological Association, the Council of State Governments, and the Centers for Disease Control and Prevention have all found that extreme discipline, including arrests, predicts grade retention, school dropout, and future involvement in the juvenile and criminal justice systems. As a result, students face lasting consequences, not only in the justice system, but also when applying for college, the military, or a job. Okay, point 4 is resource officers have not been shown to increase school safety and in fact often create a hostile environment. It says there's no clear correlation between police and schools and student safety. And placing more police in schools clearly harms the relationships between youth and adults. Police officers do not have extensive coursework in child and adolescent development. Also, and this is important, there is no uniform approach to determining the role of police in schools. And the line between matters of school safety and those that amount to school discipline is sometimes non-existent. Students are frequently arrested for minor acts of disobedience and disruption, such as using cell phones, disrespecting teachers, and getting into loud arguments. Schools with SROs increasingly turn over more and more school discipline to these officers. And then there are lots of reports of abusive practices. I just listed some, there are many. It says a Chicago student, a Chicago Public High School graduate testified before a U.S. Senate subcommittee. From the moment we stepped through the doors in the morning, we were faced with metal detectors, x-ray machines, and uniformed security. My school's environment was very tense. The halls were full of school security officers whose only purpose seemed to be to serve students with detentions or suspensions. Many of the school security officers were very disrespectful. Some of them spoke to us as if we were animals. This was nerve-wracking for me because although I was an honor student, I felt constantly in a state of alert, afraid to make even the smallest mistake that could enable the security officers to serve me with a detention. Then there's an honor student in Texas was forced to spend a night in jail when she missed class to go to work to support her family. A kindergarten in Georgia was handcuffed and arrested for throwing a tantrum. In Kentucky, a sheriff's deputy handcuffed 2 disabled children, an 8-year-old and a 9-year-old, for minor disorderly behavior related to their disabilities. Obviously, the officer had received no special training in dealing with special needs children, and the school's decision to rely on untrained armed police to manage the behavior of special needs students is deeply problematic. And then there's one example from a young female high school student. When security guards searched me in school for my cell phone, the usual routine is for them to pat me on my chest and rub their hand down my cleavage. Then they make us lift and shake our bras out. Also, they would run their hands down from our waist to our ankles. Next, they turn us around and pat our back pockets. At the very end, they use the wand to search us thoroughly. Now, of course, having a cell phone is really not a criminal act. The American Psychological Association has found that zero tolerance and other harsh disciplinary approaches do not improve school safety. And further research shows that excessive and inappropriate reliance on school-based law enforcement officers can actually promote disorder and distrust in schools. Okay, the next point is these programs are costly for school districts and for police department functioning. It says parents in Chicago are advocating for the $33 million that the Chicago Public Schools spend on school police to be shifted toward funding more social and emotional supports for students and funding for restorative justice programs in schools. Then it says that New York City spends $750 million a year on police. The Denver School District paid $1.2 million annually to the Denver Police Department. And then this quote, every dollar that goes into police, metal detectors, and surveillance cameras is a dollar that could have been used for teachers, guidance counselors, school psychologists, and program supports for young people. There are high costs for the police also in terms of their ability to perform their primary duties. And this is a quote, instead of having law enforcement personnel devote their energies to what they were trained to do, which is to address serious criminal behaviors that erode public safety, they are placed in schools where they tend to spend valuable time on minor or even trivial offenses. This compromises rather than enhances public safety, because time that could be spent addressing the challenges associated with serious crimes is instead spent responding to school behaviors. The International Association of Chiefs of Police commented, the deployment of at least one officer to each of the roughly 100,000 schools in this nation would result in the reassignment of nearly 1/7 of American law enforcement officers. Law enforcement should be allowed to concentrate their efforts on preventing, investigating, and responding to crime where it is occurring. Okay, the next point is some cities and states are working to minimize or eliminate school resource officers and divert the money to counselors, social workers, psychologists, nurses, teachers, and other supportive programming. And they have a story of Colorado. After the Columbine shooting, Colorado increased security and police presence in schools in an effort to make schools safer. With these changes, Colorado saw increasing numbers of students arrested in school, mostly for minor offenses, as opposed to having weapons, which was the type of offense originally intended to address. For example, between 2000 and 2004, Denver experienced a 71% increase in school referrals to law enforcement. The majority for minor behaviors like use of obscenities, disruptive appearance, and destruction of non-school property. So anyway, in Colorado, they've been working to minimize law enforcement in school. There's an organization called Padres y Jóvenes Unidos, which I think is Spanish for parents and children together, advocated for and achieved reforms that dramatically revised the discipline code with a specific focus on reducing police involvement in routine school matters. And they are currently working to even more effectively limit the role of police in their schools. All right, the next section is called alternatives. And because we're talking about the criminal justice instead of education, I don't know if you want me to go into those. It's ideas for different kinds of approaches for discipline and
I
handling
think-
the children at school.
Could you, Jane, could you talk about the memorandum thing? Because we might run out of time. I'll switch over to the memorandum of
Okay,
understanding.
the second question was, because I doubt if many school districts are going to start eliminating the police from their schools. The second question is, should the state of Illinois require any school district employing school resource officers to have a written memorandum of understanding with the law enforcement agency providing the officers? And a memorandum of understanding is a written document that lays out in detail, and this particular one is a sample memorandum that I got from a friend of mine over in Missouri who's with a group that works on the school to prison pipeline issue. So she sent me this model, and it's very, very thorough. It says, it talks about ensuring that the police are only involved with criminal matters and that matters of school discipline are to be handled by school personnel. They have, rules about when and how a student can be interviewed by a police officer. The parents have to be present, and it has rules for data that need to be collected. Any kind of referrals has to be documented, and there have to be records kept on how many students and all their demographic information and what the resolution was of this situation. There's training that these officers have some training. It's pretty minimal, but some training at least with child and adolescent development and psychology and so forth. They have to be trained with de-escalation and alternative approaches to student behavior. They actually have a long list marked from A to U, and B, C, D, E, F, all the way down to U, on what items are not criminal matters. So disorderly conduct such as yelling, disrupting class, throwing food, or running is not a criminal behavior. Failure to participate in class or being unprepared for class. Anyway, I'm not going to read all of those. There should be a use of force protocol specifying, whether you can use pepper spray or mace or handcuffs or tasers or all of these things on children in school.
Jane, I think I'm going to interrupt you here. You've done so much work on this, but I'm going to put these, or have Becky, I don't know if I can do it anyway. We're going to put them in the documents that we're sharing. And Jane also has, I also have a copy of the Edwardsville School Memorandum. What do you call it then? Memorandum of Understanding that Edwardsville School.
Edwardsville calls it something different. It's not called a memorandum of understanding, but that's what it is basically. Yeah,
So
I just got it today, and it would be interesting to compare that to this model. I looked over it quickly because I just got it this afternoon. It's definitely not as detailed as this model that I'm looking at, but
we'll put that on the, and maybe that's something that we can look at later, maybe. Or this committee, if we stay together, might look at that and make recommendations based on that. But Chris?
That the state of Illinois
Can I say, I want to say, Jane, thank you. I really appreciated that. I had 2 years in 1968 to 70 working in an all-black, low-income middle school in South Carolina. And I can understand the emotions that are involved in working with students who can be unruly. But right now, here in Edwardsville, there is one person that I'm looking at right now with a blue background named Rachel Tompkins. I'd like to hear her thoughts because I know she's an expert on these kinds of situations with how kids, youngsters can be difficult to deal with.
I really want to thank Jane. Thank you. I think you did great work. I thought the research you did about the effects of having an SRO in the school, I think that is really stands out. I don't think we should shrink from having a position that there should not be a police presence in school. I was very convinced by what you were saying because, schools can refer legal and police problems to police departments and handle their discipline with a lot less money being spent in much more intelligent ways. And this clearly is not effective. I've never felt like it was, but I think you gave us the research. So I appreciate it very much. It was a great job.
Susan, did you want to say something?
I just want to say that I think there should be less emphasis in talking about changes here in the police participation as with what the school districts are requiring for the police to do. They have no business having the police do all of these mamby-pamby disciplinary matters. And the police just come in to assist the schools, and then they're thrust upon to do all of these other things. It sounds like a school district issue to me. And there is a place for an SRO for more serious matters. And also, if it were directed, in the way of the old, what was the program? DARE program, as a positive influence. I know of many, many instances of students who approached SROs because they were there and told them of problems that they had at home, which were later taken out of the school and investigated.
Right, but that really isn't a police function.
Yeah,
I mean,
Yes.
why couldn't they talk to the counselor about that, and then the counselor refers it to a police officer?
Well, evidently these people didn't feel comfortable with that and felt comfortable with the police officer. The counselors at schools have too much to do.
right.
Unless they want to invest in having more counselors there,
Right.
that's a positive.
The
But
point is that you could spend that money on someone who could take a position that wasn't law enforcement on family problems. I mean, it's definitely clear that there are plenty of family problems. I don't think the police are the best first responders to family problems at all.
Oh my gosh, child abuse and sexual abuse? Yes, they are.
You know
When the
what?
school district won't do anything about some of it, there were teachers in that school who were not reprimanded
Well,
because
school districts are mandated reporters of sexual and
They
child
were-
abuse.
but they were not doing it. And I could give
Well,
you specific
That's
examples.
something to hold them responsible for, but that doesn't really argue in favor of having an SRO officer for that purpose,
I
in
think
my
again,
opinion.
that you're throwing away the baby with the bathwater.
I
Look at-
think the research shows us that it isn't really helpful. And there were many years where there weren't police officers in school. And when there were legal problems or police problems, the school could make a referral. It seemed, I don't know that
Yep.
it's made any,
I don't know.
the research certainly doesn't indicate any difference that's a positive.
And why were the monitoring, I'm losing my
Metal
word,
detectors?
metal detectors put into schools? They were put into schools to protect the students.
I'm not talking about the metal detectors. I'm talking about the policemen.
Well, this was a big issue that was made in several of the comments about metal detectors.
Correct. I heard it.
You're throwing the baby away with the bathwater.
I'm
Well,
not
haven't we
Well,
had a couple
happy with
instances?
the officers.
Haven't
I
we had a
think we
couple
need to-
instances in Edwardsville where they've had gang fights or, girls going at each other with knives or whatever? And do we expect the teachers to be able to break that up?
Well, you can call.
Well, I know
for
some
the
teachers who
police,
wanted
like
to.
anybody would, anywhere.
How far are our police from the high school?
Oh, that shouldn't determine anything.
Well, then are we gonna
They're
put
along the
police
way.
are we
They're
gonna put,
along the way.
are we gonna put a police officer everywhere? Are we gonna have them in our churches, because we do know.
Schools are fully able to handle most discipline problems. It's just that they use police for this, and that turns out to involve the legal system and things that used to not involve the legal system. I think that was your point, and I think it's an excellent point.
I worked in a Collinsville School District as a social worker at the high school. And what I saw is if a kid didn't have too much of a problem, depending what the problem was, it was sent to the assistant principal or the principals, depending on the child. They even had one of the assistant principal that dealt with special ed children only because they had a better understanding and they had a background with it. And I saw as the years go by, this last year was the last year I worked in the Collinsville school. I retired when COVID closed down. But I saw an influx of things happening with minor problems sometimes that were sent to the police as time went on because we got more comfortable. But it also made a difference with the type of police officer you had, the rapport that they had with the children. Because sometimes that would make a big difference because they knew that child. But as a social worker, I was called in to deal with certain kids because I knew what their background was. And same thing with child abuse. If there was abuse, that's what's a hotline. I had to call hotlines. And that's what they're for. So we do not always need the police. I mean, I think there is,
Who investigates child abuse?
I call the hotline and then we have it's through social services. They have
Police
social
and the
services,
police.
their job.
The job is the police to investigate for criminal acts.
No,
But
Yes.
child abuse
Yes.
is.
Right,
As
but-
a prosecutor, I never had a social worker or a DCFS investigator come up and get charges. That's not their job.
No, those are criminal charges. You're
That's
asking.
what
who
we're talking
investigates
about.
the
Child
abuse.
abuse is a criminal act.
yes, but it
No,
has
the
to be
criminal
investigated.
side is
Never-
police.
We're
It's
getting
the-
way off point and we're
Okay, so
Right.
DCF investigates it. And then if it's found that it's valid, then they turn it over to police.
not necessarily, not necessarily. That's one source of child abuse investigation. One.
Okay, here's what I suggest. I think there is, Jane, I think it does come up under one of the questions, and I looked at that before and I forgot. One of the questions does say something about police officers in the schools. When we look at that question and we have to answer it, we'll see what kind of consensus, if we come up with the majority consensus or not. I suggest if there's objections to it, that we note those objections to it. So if there's objections to that, and Susan, like ones you're saying, we can note those and put in. It depends on what the majority consensus comes
A
up with.
consensus is a consensus. If the consensus says this is what we want to report, you don't have to put objections in there. Objections, that's the losers. You don't have to, you do the consensus.
Yeah, one of the
We-
responses can be that we did not come to a consensus on something. But then what
Well,
did, you know,
We
what
only have a
areas did we come
majority
to?
consensus,
Yeah,
right? We can say we had a majority consensus and this is why.
Right,
And
that's
this
all you
was the
do.
objections.
That's
I
all.
wanna-
You don't have to put objections.
I want to say something. I'm glad to hear this, all the statistics that Jane had here showing that actually many of these officers cause some of these problems, more problems than they solve. And it's interesting to see it from a statistical side. I also want to say that my grandson had an experience where a police officer, one of the school police officers, just walking down the hall, stopped and said something to the substitute teacher. The next thing, he bullied my grandson into, after about an hour of bullying him, he confessed to doing something he did not do. Now, maybe this is something, maybe this doesn't happen very often, but I'll just bet you it happens more often than you would think.
Well, I can tell you a story where a police officer, an SRO, counseled a young woman who came to him and ended up having sexual relations with her. I mean, there are always horror stories, but I don't think that happens, hopefully, very often. I mean, there are abuses and everything. And I think a lot of it is from lack of training. You have to have a specific, and all police departments have to have juvenile officers, but their juvenile officers don't
Joanne?
trained in dealing with juveniles, do not necessarily have to be then put in the position of an SRO. So, if a training is always, as we've seen, big things, and an officer who bullies a child should never be in that position. And
Okay,
that's
Joanne,
The question is, who determines, is it the school superintendent, the school board, or the teachers? Who determines, like a food fight, if the police officer is involved or is there school discipline involved? I mean, are those rules, I would not think of SRO, that's their job.
no.
But has the school turned that stuff over to them because they don't want to deal with it?
They don't want to
That's
be
my
involved.
question.
I think that's where I think that's why it's important to have the agreement that Jane talked about, which disciplinary, are the police only involved when a student strikes a teacher as opposed to sassing a teacher, or, but that has to be written. I would think that's a school board thing. Do you? I don't know.
Well,
That's-
that's what I was curious about.
That's something that
I
we,
would think it'd
we
be
could
very
look at.
specific things.
And I ran into problems with the Edwardsville School Board at one particular time, not mentioning names, who told his teachers not to report incidents where they were physically hit by a student. And several of them, because I had direct confrontation with this school superintendent about that, I said, oh no, I am here to protect your teachers, even if you aren't. And it came through SRO is how we found out about it, because the teachers were not allowed. So that kind of stuff, there needs to be if you're going to not have SROs at all, then the school district has to be responsible to the students and their teachers in more ways, to protect them. I mean, teachers were, even in Edwardsville High School, were very concerned about their protection with that kind of a policy.
Okay,
So
let's move on to where we're not going to get all these questions covered today. So we had the debate earlier about, and I'm not even sure what that question was, Susan, that you were going to prepare originally was sentencing, I think. Discussion how to approach this because of the bill that passed through the House and the Senate, the criminal reform, justice reform bill that just passed. We still have to answer our questions. Some of those things that we've talked about were covered in that, and some of them that we haven't talked about yet are covered in it. So do we want to look at the questions, and then if it comes up, Susan has read that bill and most of it, you know, and say, okay, if she sees something and says this is in the bill, then then make sure we cover that to where we understand it. Or how do we want to do this? We have, you know, until 9 o'clock to cover up the rest of the material. I wanted to talk about funding a little bit.
Carol, ask the questions, but you're gonna have to ask them because I left mine at work since I thought we were going on a different way.
I'm gonna put them up, I'm gonna put them on my screen. And that probably means that I can't see you guys. So if somebody has a question, you just need to talk up or raise your hand. Maybe other people can see. When I share a screen, can you just see what's on the screen, or do you still see each other on the side?
We see the people on the side in small blocks.
Some
All
people.
right, some of them, not everybody. So you might, or you might put it in chat. I guess I could try to monitor to that chat box if you have a question about them.
I don't know how to use the chat.
Yeah, look down at the bottom, Chris. You're muted, Chris.
I'm not muted now.
No, you
Am I?
are not.
I just want to comment that I know that United Congregations of Metro East is very much involved in lobbying for this legislation, and they're very, very happy. The legislation, next step now, it goes to the governor's office. For those of you who don't know, the governor then could veto it. I doubt that's going to happen. The thing that's I think it's important to point out with the lovely presentation that Jane put out was that she's talking about you know, the mean. These are things that they've discovered with all this research. So talking about extremes, you know, where, you know, either way from the stories that we are talking, I don't think we're accomplishing much, but I appreciate, you know, Kathy, her story, and Susan, her stories, but I think it's important to keep in mind this research was very valuable. So I'm going to leave you with that.
Yeah, and we worked on some, talking about UCM, that particular group worked on the pre-trial Fairness Act. We haven't, some of the other things too, but they have not as much. Anyway, so if I'm going to try share these questions and then, okay, share screen, hold on.
Which issue are we doing, Carol?
Well, let's go to where I can find the questions. Where the heck do I have them at? Okay. I have them, wait, I gotta see where I have them shared. Do you see that?
Nope.
No? Oh, shoot, okay. Well, all right. Go back to Zoom again. I must not have it on my laptop. Oh, here, how about this? Do you see that?
Yes.
Okay. I started highlighting things, and then when I moved my computer one time, then I lost them all. So this is, if we go back up here to, oh my gosh. So this was pretrial procedures. That had to do with the part that passed on cash bond. What else was included besides cash bond? Monitoring and stuff like electronic monitoring, was that part of that? Susan, do you know?
Well, can't we tell by looking at the questions? Can we just start with the question?
Well, yeah, we can do the questions, but I meant, okay.
That's in the new bill.
Right, should we delete okay, so this right here, it tells, let me see if I can highlight. Okay, so all of this part right here that is highlighted right now, that is the current position. So the question asked, should we delete this is kind of confusing. Oh, should we, wait a minute, is one above that? I guess not. Should we delete the existing position and revise our position based on consensus regarding the following issues? So their position right now is that the league supports a bail bond system to ensure court appearances, but opposes a system of bondsmen who provide bail monies for free. Financial ability should not be a criterion for pretrial release. Thorough evaluation and an investigation should precede the use of release on recognizance. So they were supporting the bail bond before, but they had a problem with the bail bondsman system.
Okay, they're in Illinois. I mean, I'm just as a
Right.
statement. In Illinois, we do not, and we have a statute against the use of bail bondsmen. That was continued in the new law.
Okay.
So we need to probably continue that.
And that was because bail bondsmen, that whole system is a way for bail bondsmen to make money.
And they don't follow the laws. They
Right.
don't follow the laws when they arrest people and detain them. They're renegades. They're
Right.
horrible.
So good. So we already have that law. So these positions are old. So
Right.
that probably was changed, and now you said it's changed a new one. Should we revise? Okay, so pro is, this update would replace existing positions, deleting out-of-date references to bondsmen.
We don't have bondsmen.
Yeah, well, it says deleting
On the, yeah, okay.
out-of-date reference and retaining the opposition to the concept that financial ability should not be a criterion for pretrial release. Is that a leading question or what? But anyway.
Go back up to what the original question was. We didn't actually say what that was. Not that everybody can't see it.
Well, this question is, should we delete our existing position and revise it? Well, yeah.
Yes.
Well, maybe. That's, yeah, let's just not go overboard here. That's the question.
Well, we're deleting out-of-date, it's an out-of-date reference to bondsmen if we already have a law in Illinois that says we don't have them.
Well, no, I think we can still keep that position. Just recognizing the fact that we don't have bondsmen, I think is important.
Okay, we support not having them. Should cash bail be abolished?
Well, it just has been.
Yes,
If the governor signs
The
it.
governor signs it, which he's going to.
Was that one of the provisions that it was also delayed for a couple of years? As I-
2023. It will not go into effect until 2023.
And Rachel, just looking at it, which I mean, the number of forms and committees and people who need to make up, different things, they're going to need 2 years to comply with all of this and be ready for it.
And one of the reasons they extended it was so that there could be uniform laws written in place that would apply everywhere. The problem with that cash bail is that it was considered a criminalization of poverty, that now they want there to be a risk-based assessment, on how is the person a danger to the community? Do they have a history of not showing up when they're supposed to? And are they, who are they now? So I think one of the things, maybe Susan, you had mentioned in this one is they have to say they have to identify who they'll be a threat to.
Nope,
No.
that's not in the new law.
They took that out. Okay.
To a specific person or to the community in general.
Or to the community. Okay.
Right.
So
I believe they've done, in my opinion, and I know this is going to shock a lot of people, I think they've done a really good job of identifying when and how you get someone detained, not using money. and basing it on either the seriousness of the offense and the threat to others, because what they have included, which I think is very positive and looks at the whole general reason for keeping people in jail, they look at domestic battery, which is a misdemeanor. They look at stalking, which is a misdemeanor, along with the more serious crimes when a victim is involved, and they treat them the same way. It puts a strong burden on the state to produce items, and almost a mini trial when you want to detain someone. It really is almost a mini trial. But it also affords the court the opportunity to look at the seriousness of even some misdemeanors where people are threatened really more seriously than some of the more serious felonies. But I think they've done a good job. It's hard for me, and I'll tell you why, because Madison County does this anyway. The only people in jail in Madison County are people that have committed very, very serious crimes, who have been to prison many times in the past, which is something you can use, or have threatened harm to others. We don't have people in jail who commit, property offenses for the most part, unless they don't show up. This bill does a very good job of almost babying, in my opinion, and that's just from my perspective, criminal defendants who don't show up for court. If you don't show up the first time, but if you do show up for your detention hearing, then we're probably not going to keep you in jail. And it requires, them to be notified of their hearing, even though they've already been notified when they're released from jail. It goes to me a little bit far in people not accepting their responsibilities and growing up. But I think they've done a good job to protect the victim, and I think, and the community. And I think that's all you can ask for a system of pretrial detention.
That is what you can ask for. And you can have, before, people that couldn't, right, they were in jail, and in some places they waited a long time, and maybe they lost their job, they had their kids taken away because no one was there to take care of them. There was a lot of problems with that. You could have had someone that had more serious offense who could pay his cash bail, and someone who didn't have a very serious offense who couldn't afford it, and they were stuck in jail. But not here. But
let me tell you, when you're angry at your officials and you want to see them thrown behind jail when they've committed acts of official misconduct, they are no longer the type of person that can be kept in jail. It's just telling you. So, because they are not a physical threat to the community.
Well,
so
somebody said, I had a quote somewhere. Who was that? That was one of those articles I couldn't have found. It says, we built jails. You know who said it? Newt Gingrich, who I was surprised.
Well, he doesn't like the president anymore either.
No, so. I know, but South Carolina had reformed a lot of the bills. But he says, we build prisons for people who we are afraid of, but we fill them with people that we're mad at.
Right. That's good. Very good.
Anyway, never thought I agree with him. Anyway, so we are recording. So let's go down and see, should cash bail. Okay, so we're past cash bail. Should defendants be detained in jail only if they are flight risk or a danger to society? So this is kind of.
That's the theme. That's the whole theme of this new law.
Yes.
Shouldn't it say if it's a violent crime as opposed to a non-violent crime?
It does.
Oh,
it does. It's one of they have like several listed things that the judge should look at. And one of them is if it's a violent crime. The other one is if the person has failed to appear in the past, they're a flight risk. So there are several things that go into making that decision. None of them relating to whether you can pay for it or
So
not.
one of the whole big things about this criminal justice reform is the mindset that we have. The mindset is, are we basing all of these things on what makes a community safe? Or how much, and versus how much of it is punitive, you know, or punitive, or, well, it is punitive, that's the other thing, you know. So does it, what we're doing, keep the community safe? Or, and looking at what is data-driven statistics, you know, about this works to keep the community safe or not? And that's the same thing with the whole thing with the policing. Is this the best way to keep the community safe? That's,
I think if they have a system set up to evaluate how dangerous they are, like she said, like Susan said, if that's the truth, then we are looking at if how dangerous they are to be back in the community.
right. Should risk assessments be transparent and designed to exclude weights that may be prejudicial against certain populations?
There's a gimme.
That's really what we've been discussing.
Yeah.
Right.
Could be.
And statistics also show that people do come back when they're not held, when they, not by bond anyway, but should
One comment about cash bail. In
Mhm.
certain cases, like say embezzlement or thefts, where you don't want to keep them in jail, but if you do have a cash bond, it's interesting how, in my experience, they were able to come up with, like, you know, $2,000 in bond, which could be used for restitution, as opposed to later when they're ordered to pay restitution, you know, they say they don't have that
Don't
money.
have money. Yeah.
I'm just saying, it's a little safeguard for people to try to get their money back for them. But
Should electronic monitoring be used rarely for offenders? This is another misleading question, but should electronic monitoring be used rarely for offenders prior to trial and or sentencing?
that's in the new law.
And what does it, so it talks about electronic monitoring in there?
It does.
I don't know. What does it say? Oh, it says you can use.
Find it. I'll find it and read it to you. I've got that one marked on here. Just a minute. It'll take me a minute.
All right, look for that one. Must the bond court judge review the public safety assessment that is the basis of determination to an individual's release? A lot of these, well, what's in, we can look, okay, we can look what's in there. Do we even have bond court judges? This is kind of.
Well, that's Chicago talk for you.
Oh.
No, our judges are our judges here.
I don't know.
It's a different one every day.
Should pretrial service providers remind defendants of court appearances? That's what Susan was saying. Now, I guess
it's not really in the act. Thank goodness.
It's not in the act. So that does add to costs, you know, if you're reminding of defendants and everything, but and people say, no, it's the defendant's own responsibility to remember court dates. So I don't know what you think about that. That's a question we have to ask her, answer, I guess. I think it helped. I don't know. I think it helped. I mean, some people have a lot going on in their lives.
Carol, they get a piece of paper.
Well, yeah, that's the reminder.
That's right. And you should be responsible enough, if you're in the criminal justice system, to keep that piece of paper and know when you're supposed to return to court.
Well, that's right.
That's part of civics. And you better start learning now. Sorry.
Hey, she's a little tough.
It's a minor thing. It's a minor thing. And in order for your attorney to represent you, let me tell you, this comes from a defense attorney too. You know, we call and remind our clients. I don't see why we should have to.
Well, I hope they, yeah, tell their attorneys too. So, all right, anyway. Should an attorney, public defender be present for all defendants at all hearings?
They are. It's required by the Constitution.
Why are they even asking that question then?
Because they wanted, the original act, or some of the comments were that a public defender should be there when someone is arrested. Now, I don't know how they would do that in counties that have part-time public defenders.
Now, who said that? That was in the,
That is in some requests that are made by some organizations
okay.
that they should be there when they're arrested.
It says right here, the need for a lawyer was illustrated by Cook County Public Defender. She spoke a relatively new program which provides for 9 on-call attorneys who can be called to represent arrestees at every police station in Cook County, 24-hour days, 365 days a year. The intent is to provide immediate defense for arrestees at the police station, where it was found that 20% of the cases were dismissed.
And really, how are you supposed to do that at that level? You know, you're going to have to require a prosecutor to be there and a judge to be there at every time of arrest. Otherwise, that's going to be a very expensive proposition to put that. And I can tell you one thing, that's going to be one of the first things that would be appealed out of a bill like that as far as its constitutionality, because the Supreme Court has not seen that to be a time when the constitutional right to a lawyer attaches. Now, if they want to do that in Cook County and have all this money to spend, God bless them. But you're not going to find that in Greene County when they have a part-time public defender. And, you know, we're lucky if we see them like every 2 times a week.
Rachel, did you want to say something?
It would be hard. I think it'd be very hard to have that. I presume that's to try to make it equivalent, because of course, people who are arrested who have private attorneys do have an attorney there at
No,
that.
no, they're not. No,
And-
they're not.
And I guess it's
Arrested?
trying to even the playing field. I think it would be very difficult to hire sufficient attorneys to do that.
Private attorneys are not allowed at that stage.
When you're
At the-
arrested, if I were arrested and brought to the station, I would call an attorney.
You would call an attorney, but that attorney cannot argue whether you should be charged or not, which is what this public defender is saying, that cases are dismissed. You
Well,
are called there,
Being questioned, you can have an attorney present.
and anybody can.
Mhm.
Anybody can, whether you have an attorney or not. But she's saying you should be there to argue whether there was a crime committed and whether they should be released. It's different from saying, I want to have an attorney present, period.
Well, you
That-
know,
That's different.
are they
You cannot
are
In
they-
order, I'm sorry, go ahead, Rachel.
Wouldn't that be the role, though, of your private attorney to establish that there's a legitimate reason that you should have been?
Not then, because the officers, it might still be investigating the crime. And that is part of his case, is to arrest the person and see if they want, to give a statement. But they have 48 hours to present that case to a prosecutor. There are usually no charges at that time. Now, if you're arrested and you've been charged already, then you proceed immediately to see a judge within 24 hours or 48 hours if it's a weekend. So you see a judge, and once you see a judge, you're appointed an attorney, and attorneys, but both sides have to be there. And that's in a courtroom session, not at 2 o'clock in the morning. I'm telling you what, I'd find it hard to ask Judge Knapp to come out at 2 o'clock in the morning so a public defender can argue whether there's enough evidence at that point to charge the person. It's not going to happen.
All right, well,
As though there's a term, I read that as just having an attorney present, like a private attorney might be.
oh, it said in order to see whether they should be retained. Some of these things, yeah, I think we need to know more about. I don't know how we're going to answer them. Restorative justice, I'm moving along here because we're short on time. Restorative justice, we talked about that already, thanks to Anne, who did such a great job on that.
There's also a lot more in the act about restorative justice, at least in the prison system. There's a lot in that act about people getting credit for taking classes and having associate degrees that takes time off of their sentence, which I think, and there is also new provisions for it's called MSR, mandatory supervised release, which is parole. And it reduces the time you're on parole in most cases, except for violent crimes. So there are a lot of good changes there as far as restorative justice goes. So
Some of that will come up under when you talk about recidivism too, about,
no, I don't know about that.
well, what impacts that. So this question 9 is about emerging adults. This might be a little controversial. Should emerging adults in the criminal justice system be treated in a developmentally appropriate manner, recognizing that those in this age group are not fully mature and culpable for their actions? So I'll tell you right now, so, you know, it goes, so what this is saying basically is that the human brain is still developing during this time, and that you can, you know, that maybe there's things that would affect your actions, such as being impulsive or being swayed by your peers more. I have to see, I need to see the list here, the other things, but they're saying, you know, that you're not emotionally, when you're doing some of these things. And it says that the emerging youths are overrepresented in the Illinois criminal system, primarily for nonviolent and minor offenses, and they bear the brunt of the worst systematic racial disparities, systemic. Emerging adults comprise 10% of the general population in Illinois, yet accounted for 34% of the total arrests and 28% of individuals sentenced to incarceration. Those emerging adults admitted to prison in 2013, 73% were incarcerated for nonviolent offenses. So African Americans emerging adults are incarcerated at a rate 9.4 times greater than their white peers in Illinois. Illinois has one of the highest incarceration rates of African Americans emerging adults in the country, 3 times higher than New York and 2.5 times higher than California. So, you know, so they're saying, you know, should that be taken into consideration? I'm not sure what it talks about, if it's with sentencing, I guess, or lengths of sentencing. What are they taking into consideration here? I'm not real sure. But the con to it is that, you know, people say, well, if you're 18-year-old, you're old enough to vote, you're old enough to go into the military, you know, and go along with all the responsibilities that goes along in the military. So,
well, my con to it, and I think Carol and I talked about it yesterday when I didn't feel well, I'm sorry, is that some of these offenses, you know, right from wrong. That's all you need to know. And if you've got other issues that inhibit you from being responsible for your actions, for some type of mental disability, most of the kids on the street have more street smarts than we'd ever think about, being the white privileged class. And some of those things are just kind of petty. I think if you've got a problem, if you've got a mental issue of some sort, that's going to be taken into consideration. And yes, it should. But simply because you're, you know.
Well, I think maybe it has to do with sentencing. You know, sentencing an 8-year-old to life in prison is.
Oh, well, that doesn't happen.
Long.
So.
well, so this says part of his emerging adults are highly amenable to positive change and development and desistance from criminal offending if justice stakeholders and other support systems respond effectively. So I think part of it is about sentencing, something that maybe there might be some circumstances where you would sentence an adult with a different, you know, but if they're younger, they might respond better to.
It depends on if you've been in trouble before too. And I think, Illinois has a wonderful program that most defense attorneys do not take advantage of. And that is for all property, nonviolent crimes, felonies. There's a probation that you can be placed on. And when you're done with it, it's off your record. And this is usually for first-time offenders who are usually obviously in that age range. But defense attorneys don't take advantage of it. And that's a system where it goes totally off your record. It doesn't interfere with your life. You don't have to worry about it later. If you're young and impressionable and whatever, that is all taken into account. It's like first offender drug programs.
Is that a specialty court thing, or that's just?
That's a statute.
Well,
That's a sentencing statute that nobody came to me with. I had to offer it to people. Why don't you think about this for your, now, you know what we do in Madison County, again, this is illegal, and I will take credit for it because defense attorneys love it. And I started it for first offenders like these kids. Look, you do a year's probation, you don't get in trouble, you follow all the programs recommended, we're going to dismiss it. We retain jurisdiction and we'll dismiss it. That's the same thing as that statute, but for some reason, I don't know if it's all over the state, but at least in Madison County, they don't take advantage of it. And I think
to make sure then, so we need to make sure that is high, that's highlighted, that, we know.
Alternative dispositions maybe for younger people. And there are a lot of them out there.
I think we should quit sending 18-year-olds to war is what I think. Anyway, what Kathy?
We can't stop that, Carol.
The only thing is, I guess when they're in the military, they're under pretty strict supervision.
In the military?
Yes.
I don't know when they're over. Not when they're over in Afghanistan or somewhere. Okay,
That's
Kathy.
probably true.
Kathy?
Carol, can we back up just for a minute to electronic monitoring? Because I found.
Okay, wait, can Kathy make her statement first?
I think we're lucky in Madison County because we have the mental health courts that also look at, I don't know if it's all over the state, but we were lucky because we have that. We have programs for drug problems and so forth, that if they can get their act together and get the help that they need. And so I think that is helping some of these kids that are in that age range, especially, that are making big mistakes that don't realize the impact, get the help they need so they don't reoffend. So I feel very fortunate to be in Madison County for that reason.
Right.
And we use those courts. It's not like they're there and we snub our nose. Madison County started them in the state and we use them regularly.
Yes.
Okay, what about electronic monitoring?
Wait, no. She just gave me a good lead in to praise Alton Police.
Okay, tell your story. Yes, you have a story.
I got to tell my story. Alton Police, just as a background, is known as the bully police of Madison County.
Okay, this is recorded, you remember?
They know. I just told the chief that today.
Okay, all right, go ahead. Just reminding.
I just talked to the chief today. They have a history. They had riots in Alton in 1970 between the blacks and the police. It was horrible. And that still continues to this day as far as cooperation between the black community and the police. Now, just in the newspapers, which I tried to get out, I don't know if we ever got that out, but just to tell you, the Alton Police with their brand new police chief, we gotta love him, has hooked up with Centerstone Mental Health Agency. They are having a mental health person in the police department. This is what I did not know. It is for helping the police on calls, but it is also for in-house police counseling, which is also part of the new law. It's going to be required, but Alton did it before it was required. And I'm so excited that they're leading the way because I told them they have already gotten calls. The chief told me today they had already gotten calls from other police departments in the county wanting to know how they set that up. And it is funded, when we talked about funding, by a state of Illinois grant. So They've got the money and they're working through it. And I said, well, and that's when I said, it's coming from a bully police department. So no police department in this county can say that there's some sissy police department like Glen Carbon or Troy. It's Alton Police, and they're a big leader. And I just think it's wonderful. I talked to them today about a couple of their police officers that did some bad stuff in a house. And I didn't believe it, but the guy had surveillance, because you just don't think that happens. You don't want to think. And when I called the police just to try to find out what I should do to see what happened, was there a search warrant? Was there something I don't know about? The assistant chief of police went out to the victim's house, talked with him about how all of his repairs were going to be taken care of. The officers, the situation was going to be reviewed. And they told me today that the officers are going to be suspended for their behavior. So they're already trying, and they were so upset in talking to me today. They said they're trying so hard to change their image and work with the community. And then these two bozos went out and acted like juvenile delinquents. So police, as bad as things are, I just want to say a good point and bravo to someone who's trying.
Okay, that question will be coming up too here later about mental health for the police.
Right. It's mandated in the new statute.
Right, but our question here says, some people will say, well, their mental health care is their own problem and they should take care of it. And this says, should it be funding for the police to have mental health support, which is what you're saying, yes.
Yes.
That should be part. So that's one of the questions. Courtroom procedures and access currently.
Want electronic monitoring first?
Oh, yes. I'm sorry, go ahead.
Electronic monitoring, GPS monitoring, or home confinement can only be imposed condition of pretrial release if no less restrictive condition of release or combination of less restrictive condition of release would reasonably ensure the appearance of the defendant for a later hearing or protect an identifiable person or persons from imminent threat of physical serious harm. If the court imposes electronic monitoring, blah, 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 it should set forth a record for the basis of its finding. The defendant gets custodial credit for each day is subjected to that program, which again is already the law, but it's in here again. That is to be reviewed after a certain period of time. And the crime victim shall be notified of the hearings of this. And just as personal experience, I got somebody out on electronic monitoring who, even though I tried to beat him in their head to leave this woman alone, he was, oh, she calls me. She needs me. I'm helping her. Well, the bozo kept getting arrested. And the only way to keep him from being arrested was to put him on electronic monitoring, which was very specific only to her address. If he came within 500 feet of her address. So they can be very sophisticated in electronic monitoring. So my comment is, it's the only way the defendant's going to get out, because they've been repetitively contacting victims. Okay, my 2 cents, I'm done on that.
All right, I don't even remember what the question, what our question was. Oh, should it be used? So yours would be under appropriate circumstances.
The same thing, to keep them, keep them there. If it's the least restrictive environment is what they're saying. And I think that's correct.
I think they're saying if they've no other way, then they can use electronic monitoring.
Right, like they've been it.
All right, courtroom procedures and access. Current league position says it's the league supports improvements in courtroom procedures that serve to minimize confusion and delay and increase fairness and efficiency. Trials should be prompt with a limit on the time the accused can be held in jail prior to trial. Sufficient numbers of well-trained judges, assistant state's attorneys, public defenders, and other court personnel are essential. uniform standards should be used for appointing public defenders. So the consensus question says, addition to the existing position, should barriers to and within the courthouse and courtrooms be eliminated whenever possible? So what barriers they're saying are, these include not only criminal justice personnel, the defendant, witnesses, and other participants, also those observing the, what? Barriers can interfere with just proceedings and therefore must be eliminated insofar as possible to accommodate all who must participate in the courtroom proceedings. This includes criminal justice personnel, defendant, witnesses, and other participants, but also those observing the proceedings, including the family members. So I guess if that's a barrier to a just proceeding, I don't know what they're saying, then they shouldn't be there.
Barriers, they say, include physical impediments, but also maybe not having enough time to fairly conduct a hearing is what I'm seeing here.
Right. The next paragraph talks about physical impediments, right? Like if someone doesn't have they're deaf and they don't have an interpreter, maybe, you know, or it doesn't say here, but I would think a language interpreter would be a barrier to a fair, just proceeding if you don't have a.
All of that's, I mean, this is a good position, but all of that is taken care of. That is a good position. I mean, if we're looking at positions, yes, that's a wonderful position.
It says, for example, accommodating women in need of a lactation area. Legislation providing for lactation areas in all courthouses only passed in 2018.
Well,
Oh, it's already done.
What's the con
That's
side?
all that's done. Illinois courtroom standards. So their con is it's not necessary for everyone to hear the proceedings.
you know, they shouldn't even have a con on some of these because they sound so horrible. You know?
I don't know. Yeah. I guess some people don't do it. So sentencing laws and procedures. This is what I had you down for today. And this is a long one. So I don't know how we're going to get through here. Sentencing laws and procedures. So I had, and there's you know, my husband said, well, what do they do in other countries? I looked up, I don't know one, and I started to read this and I couldn't get into it. I didn't get all the details enough. I might look it up. The article was talking about Germany. And compared to the number, if you compare the number of people we have to the number of people they have, we incarcerate a lot more people. But I almost need that article to say it. But their sentences, most people don't end up in prison, and the sentences are a lot shorter. I think they concentrate more on returning the people to the community. I mean, that's their goal. It's not.
That's not under sentencing laws. That's under restorative justice.
Well, how long they're sentenced for? They don't have long sentences like ours do.
I think they're more pertinent to what was going on with them in some countries too.
Well, what you show is already the existing position. What do they want to change?
They want, okay, these are the existing positions, right? Should be strict penalties. And, oh, so this is the question that one part of it revolves around the use of guns. So right now, their position says that we have the Illinois, they have a gun violence prevention position. The league believes there should be strict penalties and enforcement for all crimes committed with a handgun or an assault weapon. So they're wanting it, should they delete that? The league believes that there should be strict penalties and enforcement for all crimes committed with a handgun or assault weapon. The reason they're asking that question is they are trying to get away from mandatory sentencing. So the position we have now would say there should be mandatory sentencing that says strict penalties and enforcement for all crimes committed with a handgun or assault weapon. But what they're wanting to change it so that sentencing for a crime should be based on the actual crime, circumstances and outcomes, and not be dependent on the type of weapon used, whether it's a car, drugs, knife, rope, gun, or something else. In the final report of the Illinois State Commission on Criminal Justice Sentencing Reform, there are numerous recommendations to decrease all mandatory sentences. It also says removing or reducing the automatic enhancement for possessing a firearm during any felony crime. States that anger and fear that gun violence provokes should not lead to harsher penalties, which are politically expedient, but not proven to address the underlying causes of the violence. So I guess they're saying that mandatory sentencing on gun things does not necessarily lead to change.
I'm kind of surprised at this because I would think the league would have a position on gun control,
We do.
They
which
do.
involves these type of weapons, so that the use of these type of weapons, it would be more of a deterrent if our criminal justice system addressed them.
Well, currently, that is what the position says. They're
Okay.
asking if it needs to be changed.
Oh, yeah, but they don't seem to line up. You know, if you're trying to abolish the use of these weapons, then you should have a consistent opinion when it comes to enhancing penalties where those type of weapons are used.
I guess, yeah, well, there's definitely would have to be a difference between a handgun and an assault weapon, you know, for one thing. But I guess they're trying to move away from mandatory sentencing. I don't
It
know.
doesn't have anything to do with mandatory sentencing.
Right
Mandatory
now.
sentencing, like, okay, take residential burglary, has a required minimum sentence of 4 years in Department of Corrections. No probation, no anything, just mandatory 4 years,
If you
okay?
do what? Residential burglary?
Residential burglary. It doesn't have anything to do with the gun. Home
What-
invasion, same
What
thing.
is it? So what happens if there's a gun involved?
Then there's an enhancement, or there's an enhancement of 5 years, I think.
Mandatory.
Well,
And it doesn't really say involved, but if
mandatory.
they have the weapon on them and they don't use it, but they have it.
Well, yeah, the idea is not to have the weapon out, period.
Out.
But the new law allows the courts to deviate from mandatory minimums and implement alternate sentencing.
So they're saying here 5 things about deterrence. It states, so this is according to the National Institute of Justice, its report says that increasing the severity of punishment does little to deter crime.
Well, that's not the only reason why we have laws. One of the reasons for having laws is for punishment, not just deterrence. It's punishment. There are some situations that it may not deter some people from committing a crime, but by gosh, we got to do something because they just killed someone for no reason. You know, I mean, that's not the deterrence isn't the only reason why we have punishment.
Well, so that's the whole question though about the criminal justice system is how much of our reason we put people in jail is based on punitive punishment.
Yeah.
How much, you know, so what I'm just saying,
Yeah.
and there's difference between killing people and doing some other things, maybe using I don't know, their thing is about guns. So they're saying,
Which doesn't line up with what they're talking about, is what I'm saying.
well, I think there's,
It also looks here like they're assuming that it's a political thing, that because guns get people angry and afraid, that gun violence provokes higher sentences, and that's not useful. I think that's not a fair assumption.
well, I think they're saying, yeah, politically expedient, right? Do some people make tougher laws because it makes them look better
Yeah, no.
in the eyes of the public?
Those statutes which required minimum sentences, like residential burglary, armed robbery, home invasion, they're all violent crimes, came about as a result of public opinion at the time. And they thought that this was we had indeterminate sentencing before, and you talk about crazy, that was crazy. with the length of sentences you could get. I mean, you had people sentenced for like from 11 to 32 years. And, and you could be sentenced, you could serve any of those times in between. At least now you have X number of years to serve, whether it's 4, 5, 6, whatever, up to the maximum. But it if you wanted to change anything in that respect, look at the new law and say you favor not having it, but they don't fit. The mandatory, so that's what I don't understand. The mandatory sentencing, if they're just complaining about the guns, then that's an add-on. That's not something that.
Well, they're talking about that part of the position where the league believes there should be strict penalties and enforcement for all crimes committed with a handgun or an assault weapon. And they're saying, should we?
I think that sounds
They're
good.
probably, the way they word their questions, they're probably wanting to change that to say.
Well, I don't think so. Look at the con.
About it.
The con talks about our current position on guns.
Yeah.
Well, but here's their question. Should we delete from the existing position, the league believes that there should be strict penalties and enforcement for all crimes committed with a handgun or assault weapon?
Go up to the next page where it explains that.
Yeah, look at the con on the
Below
next
it, the
page.
con.
Okay, in
That's
the
the
league's current position, the league advocates restricting their current position. The league advocates restricting access to automatic and semi-automatic assault type weapons. These weapons present a clear and unequivocal danger. Therefore, there should be strict penalties for crime committed with a handgun. There's more certainty of being killed with the gun rather than another weapon. That's why that con says that we should not change the statement. We
Correct.
should stick
Correct.
by what we have now.
Correct.
But I think by the wording of their question that they're wanting to change it, but
But that's not
Yeah,
what we're.
I think they're just asking people's opinion
right.
on
Okay,
this thing comes up.
Yeah,
Right.
someone has raised the question. Okay, let's think about it, but
so we have to think about it. That'll be a question we have to vote on. Give our consensus on. Should we revise the position based on consensus regarding the following? Should evidence-based practices and best practices guide sentencing laws and prosecutorial decision making? Should we use evidence-based practices?
No, not for prosecutors.
Why shouldn't we use evidence-based practices? If we have evidence-based practices, we know what works best.
Right. I would think you'd want evidence-based of everything.
I think the prosecutors have a different role, which doesn't always set with evidence. I don't know what evidence-based practices means anyway.
Well, that's evidence-based is, I guess, all of the data they collect. So maybe it says this works, this deterrence works based on the evidence that we have, all the data that's collected.
But again, the criminal justice system just does not operate on the principle of deterrence.
Well, I think European, you brought up that European justice, they're much more, I think, evidence-based. I think they're more clear about what their purpose is. And so evidence-based practices would be practices that will meet those purposes, assumedly like deterrence, for example, or protection. I mean, actual safety versus punishment.
Yeah, they are geared towards, that's what they're geared towards and not punishment, but and getting people so that they can return back, reducing recidivism and getting people back into the community. Get out,
And
Kathy.
that has to do with what they do in the prisons.
Yes.
More than what the sentence is. If you talk you talk about evidence-based. There are programs, or were programs, I don't know if they are anymore. What was the school, you locals will know, where the Catholics went in East St. Louis? What was the Catholic high school there? It's now a prison.
Right.
Okay, it's Southwestern Illinois, whatever.
Mhm.
That's where they do their drug programs for Illinois. And I've talked to defendants who've come out of there, or inmates, and just, said how it changed their life. If you talk with people from there, that program, you can, and they told us as prosecutors and defense attorneys, you cannot give a sentence less than 3 years for a person to properly go through their program, which means a year and a half, because you get.
Well, don't you think evidence shows that? I mean, if they really,
But that's the maximum sentence, 3 years.
well,
1 year is the minimum. So if you send someone to DOC for a year because it's their 4th time and they've been through all the drug programs and they've been through the drug court, and you just need to try to get them someplace to get them clean and to maybe find another way of life in there, go to school or do something, they're not going to make it through a drug program. So you've wasted the efforts in trying to rehabilitate them under restrictive environment, because they've not, I'm talking about someone, and this is how our system goes, at least in Madison County, for drug offenders. First offenders, third offenders, fifth offenders are not sent to prison. You have to really, piss everyone off by, it being your 8th or 9th time and been through every program that's offered. And you try to get them into a program where they're going to be helped, and evidence-based program or evidence says you have to have a sentence of 3 years. Well, that's the maximum. And then everybody's, been out of shape because of that. But, some things, if you're going to do that, you're going to have to go all the way, is what I'm saying. You're going to have to go, okay, evidence-based says I can't send you there for the minimum in order for you to be rehabilitated with these programs. If you want to take advantage of them, because they have to want to do it. It's a voluntary program. I have to send you for 3 years and not 1.
I'm a little confused about what you're trying to say.
Why?
Evidence indicates that it's most helpful, then that would be evidence-based, and then it would be, I guess, a longer. I mean, obviously you can't necessarily mandate things that are longer than the legal limit, but.
No, but 3 years is legal. I'm saying that.
What they're saying here is that long sentences should be modified because evidence shows that lengthy sentences do not produce the desired results. Unless you want to punish somebody, I guess, and you want to take away, but if your desired results are to make communities safer, or to rehabilitate people. Anyway, so I didn't look these at long-term sentences, time to reconsider the scale of punishment. What really deters crime? The National Institute of Justice, in its report, says 5 things about deterrence. Summarizes a large body of research. The certainty of being caught is a vastly more powerful deterrent than the punishment. The sending an individual.
What does that mean? What does that mean in the criminal justice system?
I don't know.
Commit crimes because they're turning
Read all 5 issues here.
The certainty, sending an individual convicted of crime to a prison isn't a very effective way to deter crime. Police deter crime by increasing the perception that criminals will be caught and punished. Increasing the severity of punishment does little to deter crime. I don't know if people, if they won't do something because they think they're going to be in there a long time, there's no proof that the death penalty deters crime. Emerging
death penalty. That's why
emerging adults should be sentenced in a developmentally appropriate manner and not as adults. Neuroscientists, developmental researchers have found the human brain continues to develop to the age of 25. So we talked about that before, but so I guess the sentencing is that long, I guess if someone's going to commit a crime, will they not do it because they don't want to serve 10 years instead of 5 years?
Again, how are you going to protect the public? I mean, there has to be some kind of there has to be some kind of reckoning for your behavior. And what you're saying is that, okay, you sentence someone to prison for 6 years for armed robbery, which is the minimum, that sentence isn't going to deter anything. Well, again, maybe it's not for deterrence. Maybe you have to be responsible for your behavior, and armed robbery is very serious. Only offenses that you don't go to prison unless you do something really bad or you've done it many times.
Yeah, not really bad. That is not true.
What, Carol? What?
What did Cindy do really bad? That was really bad, that she went to prison for a year and a half.
Repeatedly. That's what she did. She had a long criminal history.
She'd not been in prison before. All right. Anyway, we're not going to get into specifics. Okay.
The idea of protecting that with this, with evidence-based, is that you look at what does actually protect the public, you study it, and that it may be that the longer sentence does not actually protect the public if somebody comes out more likely to recommit a crime.
Especially if it's something with drugs or alcohol, and that's the base of the problem. Sometimes and they haven't done anything that had hurt somebody, but they did something that was wrong. Sometimes, like I said, the court that they set up, if they can get the help, if they follow through with it, that would be more effective and help that person, especially you're talking about the people from 18 to 25. That would be evidence-based because they know that works.
You're trying to prevent them committing a future crime, and that's where you're trying to protect the public.
Yes.
But that's not what we're talking about,
what
though.
happens in prisons. There's a whole nother subject about whether we do or don't prepare people for success when they're released. That's a different thing too.
We haven't got to that. So this is the part right here where it talks about Germany, where they visited several German prisons, reflect upon implications. But for all the signs of progress, truly transformative change in the United States will require us to fundamentally rethink values. How do we move from a system whose core value is retribution to one that prioritizes accountability and rehabilitation? In Germany, we saw a potential model, a system that is premised on the protection of human dignity and the idea that the aim of incarceration is to prepare prisoners to lead socially responsible lives free of crime upon release. While the United States currently incarcerates 2 million people, Germany, whose population is 1/4 the size of ours, locks up only about 63,500, which translates to an incarceration rate that is 1/10 of ours. More than 80% of those convicted of crimes in Germany receive sentences of day fines based on the offense and the offender's ability to pay. Only 5% end up in prison. Of those who do, about 70% have sentences of less than 2 years, with few serving more than 15 years. Is Illinois ready to rethink? And somewhere else, also in, it doesn't go in here, but in the study or what I read about South Carolina or somewhere was they made more rooms in their prisons for people who were, had commit seriously violent crimes, instead of having space filled up with people who don't need to be there, and then you build more prisons to put the people in you need to have in there to protect
Carol, we look
safety.
beyond our prison system and look at the difference between Germany or most European countries and the United States in the way we treat our people in general.
Yeah.
And that might have a significant effect about violence. And, their whole system is different, their whole economic system, their political system, the way they treat people, and the way, they educate them, the way they get them jobs, the way they give you time off from your jobs, the way they treat, families, and
right.
It's all different. And changing our criminal justice system is the back end of it. We need to change the way we treat our people, period. in the beginning.
Well, I think
They
that goes.
won't act the way they do. You'll see in those countries, they don't have the violent crimes. They don't have the gun use. Now, yes, there's, oh yeah, Finland had that horrible, yeah, one situation in a million years. But, they don't have the daily crime rates that we have. And it's not based upon our prison system. It's based on how we treat people.
Well,
Long before
I
that.
think in this instance, we can't address the whole culture. We're addressing the culture of how we treat the prisoners.
probably
But
don't
you're not going to change the culture and by doing the changing. Those people are going to get out. They're going to be treated the same way. They're going to have the same issues, and they're going to commit the same crimes.
Okay, Kathy, did you want to say something?
Say our system is all about punishing and shame rather than accountability sometimes. And accountability doesn't always mean people, depending what their charge is. Sometimes it could be something, some other way to make accountability, whether it is, well, there's ways of doing that, whether it's being in a program that makes you accountable and you have to go through a program. That's the way we change things, is making people accountable, not instead of punishing and shaming people.
But they have those programs, but the people have to be willing to participate in them. Drug court is available to every single, not even first offender. Sometimes it's not even first offender drug user. And it's not a property. I mean, you can go to drug court if you're charged with burglary or theft, as long as it's not a violent crime. But it's a very, very small percentage of people who will accept those programs and go through them.
Are they presented with them, with their lawyers?
Absolutely.
Okay.
Absolutely. I mean, the public defender's office and the state's attorney's office and Judge Ferguson created those programs. And the public defender's office is a big, big pusher for all of those courts, except for DVAC, but that's different. But the drug court and the veterans court and all of them, mental health court, they're big pushers, but it has to be voluntary. And it's easier just to go on regular probation for these people. It's easier because all you got to do is report to your probation officer once a month. And, during COVID, you do it on TV, and, there's nothing to change their life. There's no
Right. So that's where accountability comes in.
That's right.
So what do you mean by that? They have to participate. They have to want to make that be accountable.
Well, if they're not accountable, you do it in phases. You have them. This is your choice. We sometimes putting on probation sounds like the easy way out.
It is.
And instead of being on probation, they can either go to that program if that's really their problem and that's what caused their problem, instead of going to jail. And if they and not give them the option of going for probation, because they're not accountable for their actions.
But if they don't, anybody will tell you in a drug abuse program that you have, or an alcohol abuse program, that you want to be cured. You want to be rehabilitated. If you go in and just, yeah, I'm going to do this, I'm going to do that, you're not going to get any help from it. So until that person wants to be helped, which, sometimes is never, because like you said, it's easier to do probation. It is. And then what happens when it's the fifth time that person comes up doing the same stuff or more, because they can't.
They go to prison. They go to prison.
Right.
They do.
They go to prison. And I can tell you, I mean, I have had stories where I've been, where I've sent 2 kids with similar backgrounds to prison and monitored their behavior on short sentences to see if we could modify even the short sentences, who were involved in murders. They were involved. They were not the one that pulled the trigger, but they did things like got the gun and gave it to the person and did this afterward. I mean, they were highly involved.
Right.
Because of their age, I did different things with them. Not the killer, not the shooter. But one of them went to prison, did every program available, came out with went to came out with an associate's degree, took programs like how to write a check, how to get a banking, all the little level things, did everything, came out, has never been involved in the criminal justice system again. The other person who was availed with the same things and with an attorney and a mother who were encouraging him to do everything, came out and did an armed robbery within 6 months. So,
But what's the
that's
point
what
of it?
you're faced with. That's the stuff you're faced with as a prosecutor and someone in the criminal justice system. A person who's been given every opportunity.
Okay, so how does that fit? I don't know how that fits into what we're talking about. The link to the sentence.
Because you're talking about not sending them to prison for very long. And that sometimes is your accountability, in my opinion. If
Well-
you've given we don't send you. I don't know. I'm sorry. Being involved, I know they don't send people to prison for their first offense in most cases, unless they killed somebody or it was very, very violent.
Okay, we need to, I don't know if it said anything here about first offense, but let's go over these other questions here. Should racial impact statements inform or any new criminal law or regulation? So saying that the premise behind racial impact statements is that policies often have unintended consequences that would be best addressed prior to adoption of new initiatives. In this sense, they are similar to fiscal and environmental impact statements. So should policymakers contemplating new construction projects or social initiatives routinely conduct such assessments, which are now widely reviewed as responsible mechanisms of government. So I guess they're saying that anything that you put in place needs to have a racial impact statement. How is this law going to impact minority communities? Or, well, racial minority communities? You have to read through this. This is a question, at this point, people are going to have to read through this, but that's a question we have to look at. There's examples here. But part of that is, I guess, at the height of the war on drugs, Congress approved tough mandatory minimum sentences for drug offenses. Among the most severe sentences were those prescribed for crack cocaine. The law placed the quantity of crack that triggered the law's 5 and 10-year mandatory minimum sentences at 100 times lower than what was required for offenses involving powder cocaine, a substance pharmacologically similar to crack. So this had a overwhelmingly disproportionate impact on African Americans living in impoverished inner city neighborhoods because crack cocaine was sold in cheaper amounts than the powder form. That's why the U.S. Sentencing Commission, a bipartisan and independent agency, urged Congress for more than a decade to fix the sentencing disparity between the two substances. That, which they had, but that shows the difference, about why do they have this difference?
And Illinois never had that kind of a law.
Well,
but it's a federal law, and the federal law still does not recognize the difference between cannabis and other drugs.
The law disparity is still unjustified, but the 2010 form was a step in the right direction.
Well, the feds are always behind the states when that comes. The decriminalization of marijuana needed to start at the top.
Right.
Okay,
it didn't. It started with almost every state.
Right.
Right. Should legislation that reduces penalties for a crime also benefit those previously convicted and sentenced for that crime? So that means retroactive.
I think so, especially because the drug, you said the drug laws that were in place in the 80s. You also, in California, I know there were a lot of judges that was so against what was happening that they quit. They had a lot of people that quit because they did not. They had no option when somebody was caught with drugs.
was
because of
horrible.
mandatory things. It was awful.
It was horrible. I
Yeah.
represented somebody who was just a minor offender, and he got 3 years, and he served it in Wyoming, where his family couldn't come visit him.
Yep.
They're horrible. The feds are horrible.
Well-
And that's when they decriminalized cannabis in Illinois, they made it possible to go back for those people who were convicted of, not the real serious ones, but, and sure, yeah,
Yes. I would
that's
like to see that
very
happen.
fair.
Okay, so I guess there is some things in here that talks about there's issues related to the legality of sentencing retroactivity. Illinois Justice Project sent a questionnaire about that statement, and I haven't read, I have to admit that I have not read this question all the way through. If anyone's their con says anyone convicted of a crime, particularly by a jury, then that person should serve out that sentence, even if the law gets changed. You do the crime, you serve the time.
Well,
That sounds like Missouri.
yeah, I disagree with that one.
All right, should the charge of felony murder be abolished? Was this addressed in that, Susan?
It was. Let me find it.
All right, we're over 9 o'clock, so go ahead and then,
Yes, I think you better sum up here because it is getting over 2 hours.
okay, you can address that. Then I do have one thing I want to say about funding, because that's a big issue on a lot of this.
Gosh, where is it? Oh, felony murder.
You're gonna have to read through these if we're not gonna do them, we're not gonna schedule another session, then you're just gonna have to read through these. And
I recommend that everybody read them on their own before we take the consensus.
before we take the consensus. Susan, are you looking for yours?
I got it.
All right, so what does it say about that felony murder?
No, I'm just saying, I think it would be wise for people to read this on their own instead of going through this, for another 2 hours tonight.
Oh, we're not going to do that, right?
Read this.
No, we're not, no. Susan, do you want to say what it says in that bill about that?
It redefines the definition of what is required, or what the definition of first degree murder is. And it lists the first 3, which are the same, unchanged. The third one is he or she acting alone or with one or more participants commits or attempts to commit a forcible felony or other than second degree murder, and in the course of or in furtherance of such crime or flight therefrom, he or she or another participant causes the death of a person.
Can you put that in our language?
I have
I
an
don't see
example.
how it's much, what it left
Yes.
out was the death of a person, he or she is attempting or committing a forcible felony other than second degree murder. I don't think there's much difference. I don't understand the difference.
You know what? The example would be is if they've been called and because a house was being robbed and the people were there, and the people that committed that crime fled by by excuse me, a vehicle. They've been chased by a police, and say there was a car crash, even if it was a police car crash, and somebody died in that, they could be penalized for that.
Right, but there's not, they said that there was a change in the law. There really isn't any change from what I'm reading. That's the law now. And the change is only eliminating that last sentence, which doesn't have too much effect.
All right,
Oh,
well,
no, it says attempts to commit. I don't see how it changes it, actually.
all right. Well,
Still
the one thing I want to point out here too is on recidivism, is that one of the problems we have, because it talks about, and I don't have the statistics up here, about how many people go back again and how soon, they go back. And a lot of that has to do with things such as they come out without, they don't have money, they don't have housing. They banned the box on employment in Illinois. An employer can no longer ask if you're a felon, but on the application. But I think on a school application, they can ask that still. I'm not sure. So people come out, and then you come out and you have nowhere to go, and you have no money, and you might, you don't maybe even have clothes or anything, depending on what circumstances you left. And so you're gonna do what you can to survive, So debt is a serious barrier. It's saying what the barriers are here, and we have to find the difficulty in housing, poor education, preparation, employment. I think some people lose their licenses for occupations. In some cases, I can understand that if you go in for writing bad checks and stuff like that, you might not be able to have your license to be a CPA, but there's the whole thing, we have to change a mentality too about how we address people who come out who have been in prison and how we get them back into society. The thing that I had on how much, and I don't have those statistics here, but it costs, how much it costs to incarcerate a person, per day is like $42,000 to $45,000 per year. And the costs of, and I need to find that, I'm gonna put it on the page where we have our things, is the cost of recidivism. And this was in South Carolina, maybe, on funding. They found, when you reduce recidivism and all the cost that it is going through finding people and chasing them and getting them back in and everything, you save a lot of money if you can reduce recidivism. And that money can be put into the things that make the community safer in the beginning so people don't commit the crimes. So, it's really important. It impacts the people, it impacts the communities when the people come out and they don't have the support they need to get jobs or, to become productive citizens. Besides the safety of your community and a human dignity aspect, it costs a lot of money, the system, so that's where you come up with funding. We say, well, this is a system we operate now, and there's not money to do these. But if you make some of these changes happen, and they have data from states that have done it, if you make changes such as reducing the number of people that go back, then you come up with money that can be used in a better way. So, part of the funding for these programs is based on how we change our system. It's not that the money, So
It's just like what we were talking about, having an attorney or public defender present. It said when it found that 20% of the cases were dismissed. Well, there's a savings right there that would help pay for your program.
Mm-hmm. Right. So I think we have to.
But then I'm sorry, that example doesn't talk about how much you have to pay your public defender, your state's attorney, and your judge to be there.
Mm-hmm.
So
right. But I just want to use that when people say there isn't money for these programs, that if we make changes, there is money. It's that, we have to, and then it needs to go into making our communities safer, reimagining what does community safety mean? Does it mean having a strong police force that comes in when we have crimes, and arrest people and everything? Or does it mean providing the safe communities in the first place, communities that thrive in the first place, so the crime doesn't happen? How can we reimagine what we call community safety? It also makes the police officers that we have a lot safer. When you have that trust breakdown, a bad police officer who's not held accountable makes the good police officer's job more dangerous. And so I think that's points that needs to be brought up, that this is not anti-police legislation. it actually makes their job safer if you have better relationship, just like Susan talked about in Alton. If there's not a good trust relationship, people aren't even going to call and report crime that's happening.
Well, part of it is getting rid of the bad cops and making them accountable and not keep them in the loop and go to another town and start, if they've been
Right.
fired for some serious stuff, then they shouldn't be hired from somebody else. But we don't have I understand that we don't have a national registry or some type of way to check this out.
I
The
think
law
some of
does-
that was addressed in the new
That was
legislation.
addressed in that
Yes,
law.
right.
Yes, having a secure site that they can check out whether a person has been let go from other departments.
Yes.
And the certification, right?
In
But-
the certification, correct.
It has to be the police officer or the sergeant that fires them, or sometimes they let them go and they don't make it's not put in the system correctly. So it looks like that person left. He quit before he was fired,
Yeah.
and that
Right.
becomes a problem too. So there should be something in there if they quit because they don't want to face and they don't want accountability for their negative actions. And I don't know how you do that.
Kathy, because the new law, if you really need to,
I didn't read it. I just saw it before I came in because I
right,
wasn't.
no. I wouldn't, I wouldn't expect anybody to have read that. I still haven't made it through all the way. But I think some of your questions will be answered because they're setting up independent
Review.
commissions or where a person can make a complaint and that agency will investigate it to see if it's valid. I mean, it's a lot of work if they're going to take all these complaints, because believe me, most of them aren't valid, but they're taking it out of the hands of the police departments. And then that agency reports it on, not the police department.
Good.
I think you'll be happier. I think you'll be happier.
Well, hopefully that means that we get rid of the people that don't belong in.
That's
Right.
I
I think they're trying.
I read that summary that was very helpful summary. That was in that newspaper article, and that's a good place to start. And it did explain that certification process, which does sound very promising.
Yes.
There are other things that they're changing such, and I don't know if that's in this, but also like instead of rewarding police officers for the number of tickets they write, or the number of arrests they make, they reward them for other things that they do.
Good.
I can't give the examples there, but really was what I should be saying is the culture of the police force, as you know. So within the police forces now, a lot of times there's pressures on officers not to report other officers who they see doing things wrong. So there needs to be rewards for officers who do report, and there's also the racial aspect in those forces where especially if you're a minority officer in a police force that doesn't have many other Black, or minority people of color, then I think there's more pressure there a lot of times on those people to conform.
That's another thing.
It's about addressing the culture. So I'm going to reach out. I should have reached out to the committee for people to do these questions, which I didn't. I'm going to reach out to the committee to see who I would like to, when we do the consensus, I would like to have different committee people read the questions, and so I'm going to ask, who wants to read these questions, and then we'll read them and read the question and lead the discussion on it if there's still discussion. We have 2 hours to do all this consensus thing. Next on Monday from 7 till 9. So that's from here on out, it's going to be your own education on things. Anne, you're muted, Anne. Are you asking a question? You're muted.
You're muted.
Okay.
Okay. I have a question about that because just this experience tells me that there's no way we can even walk our way through all these questions in a 2-hour.
No, that's why we're trying to answer questions now ahead of time. We just
Well,
have to ask.
The thing of it is, we should have been, unfortunately, we should have been starting work on this 6 months ago. We
Right.
didn't. So whatever, we just have.
Well, I
to
just wonder if there's not
what it
something
is.
we can-
I'm sorry.
I just wonder if there's not something we can do on our own. I mean,
Yeah.
But yes, that's why I suggested everybody go to the Illinois website and read the stuff. Yes.
and somebody prepare a tally sheet that we can do, because even if there are this many of us that show up for that, are you going to go through and ask everybody to, how's that going to work?
You really don't tally. It's just a general consensus of the feeling of the group.
Well, I get that, but I don't see how we can do a consensus of all these questions in 2 hours. And I just wonder if we might not be needing
Well,
to do a
we
paper.
did it on the 18th. We have enough time after this. If we have to, there is enough time to schedule another one. The goal is to get it all done on that date so that we can get our
I'm
report
thinking
together.
logistics of it and wondering if there's a opportunity for approaching it in a different way, but
Well,
okay.
if you think of one, let us know.
Well, paper.
All
and-
right, Susan, just a minute. Chris had a comment or a question.
Yeah, I'm thinking, well, you're having this wonderful discussion, and I really support this effort because I really believe that it came about because of what occurred this past summer with the incredibly forceful work that so many people of color, Black Lives Matter people, had this influence on police departments, on states. And so having had so little history myself working in the South, and seeing the effects of Reconstruction and how you talk about doing an impact study on impact on people of color. You remember during Reconstruction, they weren't doing that. They were going after keeping people of color from voting. Okay, here we have. I'm looking at our list of members, and I only see. Well, I see John Cunningham. So I really think that it would be good to get John Cunningham to be involved with this. He's a member of the league. We're all white. Okay, that's what it is. We're all white.
I think
but
he's
it's
on
time
the mailing list too.
to be much more.
Right. Everybody was invited.
Everybody's invited. We can't make people come. Right.
Well, I think it's important to reach out, and that's a big problem. People have not been reaching out to people of color, and I think it's important to notice also that this legislation was really supported by the United Congregations of Metro East, UCM. And then Carol, you know what I'm talking about, Carol June.
We cannot partner with them because
I know, but you can still relate to them. You can still communicate with them. And
unfortunately, we don't have the time now.
It's like with the Sierra Club, we have allies, okay? So
Yeah, but that's not what
we're
we're,
making that point that this
is internal.
we need to reach out.
Oh, I think we need to do that going forward. We need to have some programs that come out of this. Plus, there's a lot of things that they took out of this amendment, when they revised it in the middle of the night. So we need to look at things they took out because they were controversial and look where our position is on that. And then we need to speak up and support our legislators who want to support those things because they're going to get a lot of pushback. So any of these things that are not yet go through that we want to support, we're going to have to be vocal about it, and you're going to have to be willing to get some pushback on it. Susan?
I have two quick things, Chris. The one thing you were talking about, stuff that happened this summer. I want to give credit though to UCM because they were pushing this pretrial no bail thing before that. I took a pledge when I ran for assistant state's attorney in support of it. And that was the election was in March, and that was at sometime before that. So UCM was responsible for a big part of this before this summer, just giving you credit. Second, if anybody wants what I found to be a good breakdown of the new statute and hit the highlights. I went on Google and put in House Bill 3653, and there popped up an article from NBC Chicago that really gave a nice breakdown. It's got it divided into police accountability, detainee, prisoner, and citizen rights. Military equipment, guys, there's a big section in military equipment that you'll love. But it,
We discussed that earlier, yes.
right. But it's now, statute. So it does a nice job of breaking it down if you don't want to read 600 pages. It
And I
talks,
want to say, to give League some credit, because there has been a committee at the state level for 3 years that put together all this information that we all have been referencing. So this has been in the works for the Illinois League for at least 3 years.
Yeah, I hope they it'll be the summer convention before they can adopt these positions, right? But any position that they already have, we could stand on, right?
Right.
Right, we have several, as it was mentioned, exactly where it stands.
Right, so any position we already have on these changes, we could come out and say the league is in support of this, and that. Yeah, by reading Katie Stewart's Facebook page, when she proposed that, this was before the revisions were any made, people were skewering her. So if you have, sometimes you can have elected officials who want to vote a certain way on a bill, but if all they get are people against the bill, they will say, well, I have to vote against it because that's what my constituents want. So we're going to have to make sure we raise our voices if we really want to see things go through on these.
but
And
this came by so quick.
well, this came up quickly here, but it's gonna.
How did you have time in the middle of the night to
Well, you
even know what it was? What was there?
You don't. They're gonna. I guarantee you, they're gonna reintroduce everything that was taken out of there. They're not gonna give up on those positions, and there'll be, so I mean, we just need to look at what's going on with this. And I think I'm glad that I think we all know more than we did, before about that. Becky, we need, yeah.
I got a suggestion for the consensus meeting. It seems like we've had a really, really good discussion. And I love that people are very passionate and informed about these issues. But I wonder if going over all of these questions for consensus purposes, your committee could, everybody take a couple of questions and read them and kind of summarize what the discussion already has said. Like, it seems like the group thinks this, because otherwise we'll just have the same discussion over again and it'll go on forever.
I think we can tell, how the discussion went.
Okay.
Right. Well, and right. So, well, I think we'll read the question and say, well, you don't take a tally, but how did you say, Joanne, do you say who is in support of this? Do we think we're in support of it?
From the general conversation, you can see if people agree with it or not.
Okay, well, we can say, yeah. I doubt there's a lot of people who haven't been on these Zoom calls that will attend.
No, I agree. I think it's probably going to be the same people on Monday night, right?
And we kind of have an impression from our discussion that, it's kind of in my head what we've kind of talked about. And I think it will, we'll be able to draw on that for the consensus questions.
I think we just need the help. It will help that night if we kind of have a general consensus, like on the questions where we thought, well, this was a good idea, but we wonder where the funding's coming through it, for it, that we note that when we say, we had
you can note that, correct.
a majority. Did they talk about a majority consensus? Is that a word? I thought I read that in the league thing that they said a majority consensus.
consensus
Majority would be,
is a word that, and consent and majority is not an adjective for it. It's
I think,
consensus.
well, I guess, but I think I read that somewhere on the reporting page where it said,
Well, find it.
I will, I'll find it before then.
Okay, or do we have a plan in effect like Becky suggested?
To,
Are you
Yeah,
going to assign the questions out to people and like set a time limit, or how are we going to do
right,
it?
right,
And
okay.
do you need me to send out any information in the invite to the consensus meeting that people don't already have?
Well,
With the pros and the cons.
we can still put, I haven't even sent any other articles yet, I think, I mean, you can remind people again and tell them that they don't have to have attended these Zooms in order to come to that, that hopefully people won't come on there and ask a lot of questions that are going to take a long time.
So that's what you have to expect, though. If they're going to show up at the end, they're going to want to give their 2 cents.
You really should read the information first.
Right.
They should read the information before they come. And
And all the meetings are on, they can look them up, correct, Becky?
Yes.
They can
Right.
go back and refer to any of these meetings.
right.
that should be made in the statement so people understand to do that. When
Yeah.
you put something
In an
up.
email, right, in an email.
Yeah.
And I do think, to Chris's point, that I hope some future programs will come out this where maybe we can get more input from the people that are impacted by these issues more. So I'm gonna, as soon as I get done here, I'm gonna type an email to the committee members. And maybe if you covered a question, maybe you would be willing to read that question in a consensus meeting, and lead that discussion a little bit about. Maybe, I think there were quite a few questions that we kind of thought were no-brainers. At least a few,
Some of them are common sense type of stuff. I would agree.
that we can say yes on. So hopefully we can get it done in 2 hours.
Carol,
Yeah,
I just have a quickie. February 9th at 6 p.m. If you're Sierra Club members or a friend of the Sierra Club, you'll be getting an announcement for our next virtual speaker series, which will feature speakers who are, the theme is going to be Black History Month. And we have, for the first time, our group has a woman of color on our executive committee, Tamika Jackson. And she's working with Virginia Wilfiley, who many of you know, on putting together this presentation. It's going to be special. I hope you all register for the announcement, and it's going to be a good one. She's also working on, part of it's going to be kind of tying in the environment with the Underground Railroad, which you may know there was an Underground Railroad location, a hangout where they hung out around Alton. So it's going to be quite a good show. If you have time.
okay, February 9th, 6 p.m., Sierra Club. And where do they access that? On Facebook Live or?
Well, it'll be on our Palisades Group Facebook page. It'll also be on the Palisades Group Sierra Club webpage, okay? But it won't be put on the webpage, until middle of next week. So just, those of you who are Sierra Club members will get an announcement, personal announcement, as long as your email addresses are current with the Sierra.
Okay, thank you. Anything else before we leave? Thank you very much, Jane. Thank you for your presentation there. And Susan, thank you for your work that you did.
Let me just tell you what my boss just said, private attorney. He says,
We're
"What?"
still recording.
Yeah, yeah, well, WTF. Is this right? No more cash bonds, no more bond assignments? Because that's how a lot of defense attorneys get paid.
But we'll find a way to raise their pay.
Okay, that's fine.
Okay.
Great.
All right, thanks.